Thank you all for coming out tonight. Thank you, Professor Dworkin and the Rowan Institute for Public Policy and Citizenship for inviting me to speak tonight. And thank you, Kate, for your wonderful words. First things first, although I am a Princeton grad, Rowan, go Tigers. Rowan holds a special place in my heart. My mother is a Glassboro State College alum, class of 1971, so also go Profs. I'm Amanda Haines, the Executive Director of the New Jersey Election Law Enforcement Commission, or ELEC. I spent 19 years prosecuting campaign finance violations for the commission, and the lawyer in me needs to make one small announcement. The opinions that I express today are my own. They don't necessarily represent what the commission believes, so please keep that in mind. Now, please indulge me as I take this opportunity to introduce you to ELEC. In 1973, the New Jersey Campaign Contributions and Expenditures Reporting Act passed both houses of the legislature and was signed by Governor William T. Cahill. The Campaign Act created ELEC. So why 1973? What led to the push to reform that created ELEC? A series of events, both national and local, led to these reforms. Essentially, the public had become cynical of elections and the dollars behind them. In New Jersey, a general awareness that those in the political sphere were taking advantage of perceived loopholes in the existing system. This stoked mistrust. Nationally, Watergate occurred on June 17, 1972. The resulting fallout was extensive, including conviction of several high-level aides and resignation of numerous staffers in the Nixon administration. A key component of the Watergate scandal was secret campaign contributions, in addition to other related campaign finance violations that occurred within the Nixon administration. This, combined with unrest over the Vietnam War, among other things, led to continued public distrust of government. In part, ELEC was created to address this cynicism by shining a light on the sources of campaign funding for all offices at every level in the state of New Jersey. We are New Jersey specific. ELEC's jurisdiction is New Jersey elective public office, from school board and fire commissioner all the way up to governor. But it does not include federal offices. So a little bit more about specifically ELEC. The agency has an agency head of 4 members, with no more than 2 of them from the same political party. Historically, that has meant 2 Democrats and 2 Republicans. However, that is not a statutory requirement. The commission can be any combination of Democrats, Republicans, or independents, or nonpartisans. It simply must not be more than 2 from the same political party. ELEC is not just bipartisan, it is truly nonpartisan. The essence of democracy is an informed electorate. ELEC embraces the fulfillment of this goal as its mission. There are 2 parts to regulating campaign finance. Part 1 is the actual regulations, most often disclosure related, and their enforcement. Part 2 is the general public's interaction with the information that's available. As I said earlier, I prosecuted campaign finance violations for 19 years. I could certainly regale you with war stories of politicians, political organizations, and sometimes attorneys behaving badly. And perhaps we can get into that during the Q&A. But the truth of the matter is, the overwhelming majority of filing entities, candidates and committees alike, report the required information in a timely manner. While we are going to do a quick history of campaign finance and explore what still needs to be done, if you walk away from tonight with anything, I want it to be that you, the voters, the public, have a role in campaign finance regulation. So it all started in 1973 with disclosure. To put that in perspective, the 1973 version of the Campaign Act required the reporting of all expenditures and all contributions over $100. All transactions were required to go through a centralized depository, and reports were required at different intervals and were available for public inspection at the commission's offices. That would require a trip to Trenton to go to our public room to view files, reports, complaints, final decisions, and other commission documents. Maybe you could make photocopies, maybe you would just take notes. It was a situation that required you to go to the Commission's offices. At that time, ELEC was granted enforcement authority, but it was not sufficiently broad to properly enforce the provisions of the Campaign Act. The first major overhaul came in 1983. The 1983 amendments were based on ELEC recommendations. Ongoing committees were required to file quarterly reports, and candidates were required to file 29 and 11 days prior to an election and 20 days after an election. These are the same intervals that still exist today. A new 48-hour notice requirement for political committees, continuing political committees, and candidates required the reporting of contributions in excess of $250 immediately before an election. Prior to these provisions, those transactions would not have been reported until after an election. And enforcement was expanded, broadly defining the universe of individuals and entities subject to penalties for violating the Campaign Act. In 1990, the Ad Hoc Commission on Legislative Ethics and Campaign Finance issued a report recommending further amendments to the Campaign Act. It found that there is a public perception that candidates may be influenced by large contributions and recommended contribution limits to counteract this perception. So contribution limits serve two purposes. First, they limit potential influence a large contributor may have over a candidate. And second, they alleviate the public fear that large donations are made expressly to influence a candidate's actions. The Ad Hoc Commission also found that campaign funds should only be used for specific purposes. They further found that perceived or actual misuse of campaign funds further erodes the public trust. It found that more information is necessary for proper disclosure, and finally, it wanted to make sure that the Election Law Enforcement Commission adjusted thresholds and limits every 4 years to make sure that we maintained a viable system of campaign financing in New Jersey. In 1993, many of these amendments were implemented. For the first time, the Campaign Act contained contribution limits for non-gubernatorial candidates and committees. The use of campaign funds was limited to 6 permissible uses, and the personal use of campaign funds by candidates is prohibited. So the only 6 uses that campaign funds can be used by candidates are campaign expenses, charitable contributions, transmittal to another candidate or committee, payment of overhead and administrative expenses, pro rata repayment of contributors, and the payment of ordinary and necessary office holding expenses. In addition, in 1993, contributions were required to be reported with the occupation and employer information of individual contributors. Again, this additional information is designed to provide the electorate with as much information as possible and an idea as to the motivation for potential contributions. Essentially, is the contribution to advance a particular industry or profession, or is it simply to advance an individual's political interest? The 48-hour notice requirements were expanded to expenditures for political committees and continuing political committees at that time, and ELEC was required to adjust specific thresholds every 4 years, and that included contribution limits. In 2004, the legislature realized that the contribution limit adjustment had gone too high. They decided that ELEC should no longer adjust contribution limits. So contribution limits were frozen at 2004 levels. Detailed contribution reporting threshold was set permanently at the time at $300 with no further adjustment. Again, this figure had been adjusted by ELEC as the statute required us to do. However, the legislature decided that that threshold needed to permanently stay at $300. The 2004 amendments required detailed reporting of all currency contributions. This was a new requirement. So just to give you an idea about currency contributions, currency is limited to $200 per contributor. So why is there such a low limit for currency? Checks and other negotiable instruments, bank transfers, credit card transactions, they all create an identifiable trail to track these contributions. So if ELEC is doing an investigation after the fact, it's easy to follow the money in a campaign account through checks, money orders, all of those things. Currency does not leave that type of trail. So by limiting the amount of a currency contributions to $200, the public can be assured that reported contributions are accurate, especially for the large contributions. And as an aside, excessive currency is one of our most egregious violations because there is a danger with currency contributions. The 2004 amendments also added 48-hour expenditure notice requirements for all remaining entities. Basically, all entities that report under the Act are now required to report all of these transactions immediately prior to elections. So we fast forward to 2023. The Elections Transparency Act was signed by Governor Murphy on April 3rd, 2023, and served as a major overhaul of the Campaign Act. It adjusted contribution limits upwards for the first time since 2004. What used to be an adjustment every 4 years is now an adjustment every 2 years for non-gubernatorial candidates and committees. The detailed contributor reporting threshold that I just discussed, being permanently set at $300, is now permanently set at $200. And 48-hour notice have transitioned into a bifurcated 72 24-hour reporting scheme for contributions and expenditures immediately before an election. The threshold to have to do that is now reduced to $200. This figure is still going to be adjusted according to our cost index adjustment every 2 years, so it will get higher, but just as a comparison, the 2023 general election, that figure was $200. The 2023 primary election, that figure was $1,900. So there's an incredible amount of additional disclosure happening now that didn't happen prior to 2023. The Elections Transparency Act also created new housekeeping accounts for state and county political party committees, and these accounts are separate organizational depositories that allow these entities to pay non-political expenses such as rent, legal fees, compliance costs, salaries. Other entities like candidates, they need to pay for that with their campaign funds. And all transactions of the housekeeping account must be reported on quarterly reports just like every other transaction of a campaign depository. Last but not least, the Elections Transparency Act created independent expenditure committees and provided basic reporting requirements. The legislature attempted to create independent expenditure committees and design reporting requirements in 2019. However, that legislation was found to be unconstitutional as it was overbroad, and ELEC was prohibited from enforcing it. So you may wonder, why the history lesson? Well, just like fashion, what is old is new again, okay? Public cynicism about elections and distrust of government processes still exists today. This time, the concern is about the infusion of funds from special interests and independent groups and the lack of transparency as to the source of those funds. Disclosure is still the best way to address these concerns. Prior to 2023, independent expenditure committees, also known as super PACs or special interests, had no reporting obligations in New Jersey. However, some independent groups voluntarily disclose both their contributions and expenditures without being obligated to do so. So what is an independent expenditure committee? These are big spending committees. You can't even be an independent expenditure committee unless you spend $7,500 in an election. So these committees have an IRS designation of 527, 501c4, or 501c6, okay, that doesn't fall within any other definition of any other reporting entity in New Jersey, and that makes expenditures, independent expenditures, in excess of $7,500 in an election. What is an independent expenditure? Clearly it's independent. What is it independent of? It's independent because it is not coordinated with a candidate or a political committee or a political party committee. It must expressly advocate the election or defeat of a clearly identified candidate, or have a clearly identified candidate and be the functional equivalent of express advocacy. The same standard exists for public questions. What is the functional equivalent of express advocacy? This is an expenditure that can only be interpreted by a reasonable person as advocating the election or defeat of a candidate. Basically, although the language does not expressly say vote for Bob or vote against Bob, the message is clearly vote for Bob or vote against Bob. Considerations include whether the communication mentions a candidate, discusses the candidate's fitness for office, and position on an issue. So what are the disclosure requirements? This is the big deal. Once an independent expenditure committee has spent $7,500 in an election, they're required to have a treasurer and open a depository and file forms with ELEC to designate those things. The registration statement they're required to file gives background information on the committee as well as those individuals that have control over the committee. And if they are individuals that control the committee, their occupation and employer information is also reported. An independent expenditure committee files election cycle reports, provided that they make an electioneering communication in an election. 29 and 11 days before an election, 20 days after an election, just like a candidate committee. The election cycle reports include all contributions in excess of $7,500 and all independent expenditures. There are no contribution limits for independent expenditure committees. But wait, why $7,500 when all other entities under the Campaign Act have to report contributions in excess of $200? And what about the danger that the contribution limits addressed back in 1993? Has all of that gone away? The key here is the independence of these entities. The US Supreme Court has found that where entities are making independent expenditures only, there is a much reduced possibility of influence and control with the communication expenditures. Therefore, the danger that the contribution limits address is not necessarily part of this equation. Disclosure is the key, but due to the independent nature of the communications, the public interest in disclosure is lower, leading to a much higher detailed reporting threshold. However, if coordination occurs between an independent expenditure committee and a candidate or political party, the protections of an independent expenditure committee, those high reporting thresholds, may no longer exist, and the entity may fall under the definition of a political committee, which would require much more detailed reporting, and it would also require the committee to be subject to contribution limits. So I mentioned an electioneering communication. Those are any communications made within 30 days of a primary election or 60 days of a general election or any other type of election. These communications have to clearly identify a candidate and expressly support or defeat that candidate. It also includes the functional equivalent of express advocacy. So that sounds familiar. Just like an independent expenditure, it has the functional equivalent of express advocacy. The only difference is that electioneering communications involve a proximity to the election. So while an independent expenditure can occur at any time, it can be for an election, it could be 4 years prior to the election, but it can be for a specific election. An electioneering communication can only occur either within 30 days of a primary election or within 60 days of any other election. So in essence, an entity must spend enough money, at least $7,500, to be an independent expenditure committee, in close enough proximity to an election to be required to file in detail. So I'm admittedly a campaign finance nerd, okay? And I'm certain some of you in the audience may be as well. However, why is a basic understanding of these committees essential for all voters? The simple truth is these independent expenditures, these electioneering communications are directly targeted at you. They communicate directly to you as voters. They appear as mailers in your mailbox, ads on Facebook and TikTok, ads on news and entertainment sites, TV commercials, and billboards. Because these entities have large sums of money to spend, they are generally very successful at transmitting their message to the target audience. And remember, as I said before, special interests. So they have a particular interest that they are pushing directly to the voters. In all likelihood, you have received mailers or seen ads on the internet of this nature. I know that I have. Of course, I also look for them, so that's... So it is important to recognize the source of these communications, because that tells you a lot of information. But how? The communication itself should provide all of the information that you need to get started. Every communication must have paid for by language. It will literally say, this communication was paid for by X. So whether that's an independent expenditure committee, a specific candidate, whoever is funding the communication has to have their name on the communication itself. Independent expenditures must also state that the communication was not made with the cooperation of a candidate or committee. Okay, so you received something from an independent expenditure committee, say. Now what? What are the resources that are available to you? ELEC is the clearinghouse for disclosure. ELEC's website contains all reports filed with the commission, and for independent expenditure committees, you take the name from the paid for by language and you search on our website, and it will pull up all reports that they've filed. So you'll be able to find their depository form. You'll be able to find the individuals who run and make the decisions about the entity. If it's close enough in proximity to an election, you'll be able to see their contribution and expenditure reports as well. What happens if you can't locate the entity on our website? Well, we have a compliance staff that's available to help you out. You can give them a call, and they'll help you find things. There's also the possibility that you are searching correctly, and the reports just don't exist. Our website also gives you the ability to request an investigation if you see something that's wrong. So if you're looking for a specific thing and it doesn't exist, perhaps you can file a request for investigation, and we can look into that issue. So ELEC's website allows the electorate to be as informed as it would like to be. Each person must decide what that information means to them and how it affects their voting decision. So what else needs to be done? Although the Elections Transparency Act provided tremendous new opportunities for access to information, more disclosure is necessary. As I stated before, these committees, they file these election cycle reports, 29, 11 days before the election, 20 days after the election. However, the 20-day report is the last report they're required to file. Candidates who also file these election cycle reports are required to continually file, even after the 20-day report, on a quarterly basis until their account comes down to a zero balance. So basically, if they have outstanding obligations, they're required to report all of the contributions that they receive even after the election to pay down those debts. No such obligation exists for these independent expenditure committees. Practically speaking, this means that one of these committees can report invoiced independent expenditures and carry them as outstanding obligations through the 20-day report without ever disclosing the contributions that support those expenditures, because the contribution is received after the close of the final report. Meaning that there's disclosure of the expenditures, which is fabulous, because that's not something that we've always had. So disclosures of the expenditures, wonderful. However, we don't get the complete picture because we don't get the complete reporting of the contributions that support those expenditures. So what's the solution? The solution is to require independent expenditure committees to just continue to report so that their quarterly reports after an election will contain the information of the contributions that are paying off those debts. This will complete the picture. One additional thing that needs to be done is that independent expenditure committee, they need to file those rapid notices that I was discussing before, these 72 24-hour notices. All other reporting entities subject to the Campaign Act have this obligation, except independent expenditure committees. That means that transactions that occur between 13 days prior to the election and the election are never reported until after the election. This 13-day period is when most of this electioneering communication occurs. So they're trying to get to the voters, influence their decisions immediately prior to the election. This is the time when reports need to be available so that the public can see where the money's coming from and where it's going. What's the solution here? Simply to require these notices. So it would be all independent expenditures over $200, just like other entities, and all contributions in excess of the $7,500 threshold. But these solutions, the disclosure, only works if the voters take notice. Sure, litigation and high-dollar penalties get a lot of press attention, but most of that occurs after an election is already completed. As I described earlier, members of the public have to engage with the disclosed information and decide what it means to each of you. The Commission is first and foremost a depository of campaign finance reports. We are here to make the information available to you. What started out as a public room full of reports, complaints, and final decisions that required a trip to Trenton to view and payment to photocopy has evolved into a website with a vast amount of information at the public's disposal. In the past year, the Commission has made even more information accessible than it ever has before. All reports received by 5 p.m. on a due date are available for public inspection that day. They are immediately put up on our website. We're always working to make the information even more accessible. As I stated, we have a compliance staff and an IT help desk available between 9 to 5, Monday through Friday, to assist you. So I want to thank you guys for coming out and for spending your evening learning a little bit about campaign finance. And I'll close the same way that I opened, with ELEC's mission statement. The essence of democracy is an informed electorate. I hope you will take it to heart and participate in campaign finance regulation by availing yourselves of the information disclosed on ELEC's website. So our website, elec.nj.gov. I encourage you guys to look into it, see what information you can find, give us a call. If you can't find things or you need some help, the information is there, so please make use of it. Thank you.
Is this on? Yeah, oh, it is. Yes, it is. Oh, hey, all right. Thank you, Amanda. I really appreciate that. Got a bunch of questions that came in, and you raised a couple of really interesting points. But let me just start, because of your encyclopedic knowledge of all of this. Was this a career that you envisioned when you were in school? And if not, what made you choose the path of, oh, I want to go into election law enforcement, or rather campaign finance law enforcement?
So I've always had an interest in politics. And when I was younger, actually thought I would be on the other side of it, potentially holding office. However, going through law school and graduating law school and learning more about the Election Law Enforcement Commission, to me, being able to work for the government, being able to, as I mentioned earlier, talking to the other students, being able to tell people that I was an ethics attorney has always been an enjoyable thing to me. So I've always been looking to work for the government, and the ELEC position sort of became available. One thing I do enjoy is being able to work in a specific area of the law, creating a little bit of an expertise in that singular area. And that's what campaign finance has been for me.
Just as a follow-up, did ELEC recruit you out of law school? Is that how that works?
I did receive a letter asking me to apply for a position, so potentially. I mean, I believe I went to Temple Law School, and I believe through their career services office, we were able to indicate if we were interested in government positions, and they sort of spread our information around. So I think it had something to do with that, but yes.
Okay. Yeah. One of the questions I thought was that interesting that came in, we live in a very unnuanced world sometimes, and there are more than a few people who are so cynical about the system of campaign finance that from their perspective, donating to a political campaign is simply legalized bribery. How do you respond to that kind of critique of the system?
So I think donating to a campaign is a very personal decision. I think the perception can be that there are all of these huge dollar amount donations that are coming into all of these candidates. That's just simply not the case. Sure, there are some people and entities that are able to give maximum contributions whenever they like. However, it's really what I would call standard public person who is writing a check for $500 because $500 is what they're willing to give to support this candidate. It's people who really believe in these candidates, not necessarily people who are attempting to control their actions. It's really members of the public participating. It's not an attempt to control, at least in my experience.
Can you speak about, obviously we live in a world of federalism. There's national level, state level regulations that can overlap, can sometimes contradict each other. So can you talk a little bit about how federal law and or US Supreme Court decisions that we've heard about, Citizens United and other kinds of things, do they have any impact on New Jersey's system of campaign finance, or that's just for federal stuff, we're dealing with governor on down here?
So the answer to that question, the either or, is yes. So while we are only dealing with governor on down as far as actual sort of offices that ELEC involves, that ELEC has jurisdiction over, the United States Constitution overlays everything. So basically, a state cannot take away a right that the United States Constitution provides. A state can provide more rights than the United States Constitution, but cannot provide fewer rights. So whenever we're regulating campaign contributions, which have been found to be political speech, freedom of speech has been, one of our most established freedoms and needs to be protected. We have to walk sort of a tightrope between regulating speech and the interest of the public to have disclosure of where those dollars come from. One example is, I talked about contribution limits. There used to be expenditure limits. However, expenditure limits were found to be unconstitutional because you are limiting political speech in a way that just does not satisfy the necessary interests to limit speech in that way. The Supreme Court is considering these issues continually. So we are always keeping an eye on what they do when it comes to campaign finance decisions. And we sometimes have to trudge our way forward. But our goal is definitely to support free speech, but also support the interest of the public to know where those dollars are coming from and how it affects their own communities.
I want to ask a follow-up on that, but let me preface it this way. Maybe you have a friend who walks into a bank and always says, if I were a crook, how would I steal from this place? So let me say, okay, if I'm involved in politics, how do I get around this system? Isn't it because of the different rules for federal as opposed to state regulation? You talked about, well, we need to know who gave to this particular independent expenditure. But couldn't you effectively hide it by having a federal group that doesn't have to report? And so then it's the Committee for a Better Tomorrow gave something to the committee where ooh, we now know who gave to this state-regulated entity. It was the Committee for a Better Tomorrow, and we've never heard of them. And there's no way to really find it. Is that a common thing that you see? Or is that just people sort of fantasizing about how to do this?
So that may be your classic parade of horribles example. We are sort of in our infancy of independent expenditure reporting requirements. So in the last election, or the last general election, the 2023 general election, there were groups that disclosed contributions from other groups. And perhaps if you're not in the know, you don't know what those other groups are. Sometimes that's where you rely on the press to step in, to do additional research. You rely on the information that's available and for people to be curious and to look into things a little bit further. But like I said, we try to make as much information available as possible. And at some point, those entities usually pop up somewhere, whether it's in New Jersey or you hear about them on national news or you see an ad for them somewhere. They pop up somewhere, so you can get information. You may just not be able to know who's exactly behind them.
Given the multiple ways in which money can get into the system, the late New Jersey political reporter, Nick Acocella, proposed, he always had this interesting plan. He kept trying to sell people on it. I wanted to run it by you. He said, look, for New Jersey to work in terms of its campaign finance regulation, there should be no limits on contributions. Bring it out in the open. If you want to write $1 million check to a campaign, then do it. But his proposal said you can't send it to the campaign. You have to send it to ELEC. ELEC photocopies the check or the wire transfer of the $1 million, posts it, and the next day the campaign gets the money. So disclosure is automatic because it works through effectively like a clearinghouse like you were using. And the idea, of course, the theory behind the system is to improve disclosure and avoid all the very surreptitious ways that people go to not show anybody where their money is coming from. When we talk about reform, this is how reform comes, because somebody has an idea and it just gains. Can I just ask, as in your position, what's your reaction to that kind of proposal? Is there any merit to it? Are there any obvious drawbacks that you would raise?
The first thing that I would bring up is the Election Law Enforcement Commission currently has 65 employees. So the immediate drawback is that we would need about 600 more employees to be able to handle, again, every candidate from school board and fire commissioner through to governor. So It's an interesting idea. It's the first time I've ever heard this idea. I feel like there's still a public cynicism about big dollar totals. And there was a reason why contribution limits stayed the same from 2004 to 2023. And it was because they thought the limits were too high. There needed to be limits, but they were too high, so they froze them. Now, in 2023, they're like, okay, well, nothing has happened in 19 years. We need to make them higher. So probably in the future at some point, they will be frozen again, just looking at history and predicting what could possibly happen. It's an interesting idea. I like contribution limits. I do think it provides at least something for the public to see as limiting potential influence. But that is a simple, clear, all-out disclosure option. That being said, it would again, as I said before, require the public to engage themselves very directly in those transactions. It's an interesting idea.
For what it's worth, I mean, in his vision, this person, when the check comes to you or the donation comes to you, you take a fee out of it. And that's how you pay for the 600 people more that you need.
A broker's fee. I like
yeah, that's it. But leaving that aside, one of the ways to limit contribution limits are through taxpayer-funded campaigns. And we provide this, I share this with the audience, we provide this for gubernatorial races. We have an open gubernatorial governor's seat coming up in 2025. At this point, it looks like there to be 8-9 people between both sides, at least, casting, trying to put their together. And almost all of them at this point seem to be ready or indicating they're going to work through the financing system. But it's only limited, our government financing system, taxpayer-funded elections, is only limited to the governor's race. So, wouldn't it help if we found a way, what are your thoughts on allowing taxpayer money to fund other kinds of races?
So in, I believe, 2006 and 2007, there was actually a legislative clean elections pilot project, which had a similar publicly financed feel to it. So I believe the exact details, basically these, in specific legislative districts, it wasn't the entire legislature, they agreed to collect only small donations. I think they were $10 or potentially less. And they agreed to spend only a specific amount on the election. And it was an interesting experiment, but when it came down to it, and I believe that ELEC recommended that it continue and it be a widespread legislative program, but when it came down to it, the legislature did not allocate us the funds to do so on a continuous basis. So the gubernatorial public financing program is sort of our pride and joy. It's something that we have run since the 70s. It is a program that, as long as a candidate has demonstrated their viability by raising and spending a specific amount of funds, they have access to a 2-for-1 match on every dollar they collect, which provides opportunities for people to run for office that may not have been able to raise the funds that another candidate might be able to raise. I don't know. I don't know if New Jersey would be willing to continually fund even a legislative election year after year. I mean, our statute has language in it that we only have the public financing program for gubernatorial elections, provided that the legislature allocates us the funds in the budget. So there is a possibility every 4 years that the legislature does not allocate those funds, in which case there will be no public financing program. Now that has not happened, but it is something that we're reliant on every 4 years.
Given, I think you leading into this next question, because you talked about, well, that the legislature is nice and gives us the funds to do things, we can do lots of stuff. If the political class, the legislative group, the executive branch, if the political class in New Jersey ignores ELEC's recommendations, requests for funding, is there a role for ELEC to play in advocating publicly for improvements to the system? Or we should be quiet, we implement with what they do, and that's what we do?
So we are required every year to issue an annual report. And our annual report to the legislature describes what we've done over the course of the past year, but it also includes a legislative recommendations section where we are able to advocate for the recommendations that we make. We have been very fortunate in that the legislature has recognized that we do have an expertise in this area of the law, and they do take into account what we recommend. Most of our publications, my Deputy Director Joe Donahue issues white papers, generally also contain legislative recommendations as to what things need to change. And those are areas where we can advocate what we need as a commission, what campaign finance things need to change moving forward.
You talked a little bit about we'd rely on the newspaper, an energetic reporter to find certain things and report certain things. It's been noted that the coverage of New Jersey politics has never been particularly great because we sit between New York and Philadelphia, where the media outlets, both newspapers and TV, are far more and clearly more focused on what's happening in their cities than what's happening across the river. New Jersey used to have several newspapers that assigned reporters to cover stuff in Trenton. Today, the State House Press Corps is a shell of what it once was. So the question came down to this: does that matter for you and your team in ELEC? Does the lack of political news coverage make your job harder, or does it make no difference?
I'm not sure it makes our job harder. It just makes our job different. So, as you were mentioning, in the past, the State House Press Corps used to be very large. Again, Joe Donahue was a reporter for years, and he tells stories all the time of coming to the public room, coming to commission meetings, writing articles about campaign finance. The media has changed in that maybe it's not, newspapers. Maybe it's politically focused websites that are writing articles about campaign finance. There are particular ones in New Jersey that pay specific attention to politics, that generally are always paying attention. But as I did tonight, I think it's important for us to reach out to people so that they're finding the information on their own. Because I do think that it's very important to have the facts in front of you instead of relying on other sources to provide you with information that may lead to whatever opinion you have with regard to the political environment.
One of the recent decisions by ELEC that garnered some publicity involved a Republican gubernatorial candidate, Bill Spadia, whose day job is the host of his own radio show on New Jersey 101.5. Spadia's opponents argued that once he announced that he was running for governor, the station was in effect providing him an in-kind contribution by giving him a platform to project and sell his message, and therefore it should be limited and regulated. As I understand it, the ELEC board disagreed for now, but said it would be watching how Spadia uses his time on the air. For those of us who have not followed these legal arguments, might you explain a little bit more about what was ELEC's thinking? Because it seems, for the layperson, if you're allowing a candidate to have their radio show, that's just a really big microphone that they're not paying for. He simply has it because of his job. Can you explain what ELEC was thinking there, the legal aspects of this?
So the main thing that went into those considerations involved the messaging. So at this point, a little bit less than a year before the election that Mr. Spadia is going to be involved in as a candidate for the Republican nomination for governor. The proximity to the election requires speech that would trigger a contribution or trigger an expenditure reporting to be express advocacy speech. You know, here's what I would do if I were governor, something like that, or vote for me, basically a commercial. Messages that are not about that are about politics overall, that are about the state of New Jersey and not about other candidates in the race, is no different than somebody writing an editorial in a newspaper, theoretically. It's a nuanced issue when it comes to that, and I can understand how it feels as though it's free advertising, and there are plenty of people who believe that that's the case. At this point, however, the commission determined that as long as there is a careful separation of the speech that occurs, at this point, it's not going to be prevented or required to be reported as a contribution in any way.
I'm just curious to follow up on that. If Bill Spadia slips and uses the magic words that he's not supposed to, does that trigger, okay, now forevermore, we're going to consider this or is it how do you deal with, well, it happened once at the 3:02 on this day. Can we turn our phone off, whoever's got that?
So, this is all hypothetical.
Yes.
This would be how I would approach it. Presumably, it would be tracked based upon the amount of time that it took, and it could be compared to how much that amount of time on the radio costs. And there could be a dollar figure attached to it, and that dollar figure would have to be reported. If it were a contribution, there would be contribution limits. If Mr. Spadia were to repay the radio station, it would be an expenditure of his campaign.
Thank you, just elaborating there. We got an interesting question. Someone submitted a question about how we compare to other states. Do you have a sense in terms of, do other states have programs that you're envious of? Like, wow, they have way more employees and they have a much more better financing, or how do we rank and compare to other states?
So there are not many states that have as extensive of campaign finance regulation that New Jersey has. There are a few, I believe Wisconsin, and I'm not thinking of other states right now. However, there are sort of state-specific issues that those states get involved in, and sometimes the structure of the state itself changes the way that they approach campaign finance, and sometimes it's not even state level, like the Philadelphia Finance Board, right? So the Philadelphia Ethics Board does all of the Philadelphia elections, or I believe New York City has a similar ethics forum. They're similar entities, but maybe they're not statewide entities. But there are campaign finance regulations across the board, but like in different states, in like the western states and Wyoming, it's just a different approach to campaign finance. It's the wide open spaces. It's a different amount of people giving funds and different ways to approach the general public. So the approach overall tends to be different. And there are groups that get together on an annual basis to discuss these sorts of things, where state agencies and local agencies that do this sort of thing get together and they discuss how they address these issues across the board. So there's always an opportunity to learn from someone else as well.
Is there a particular best practice that's out there that you'd like to bring to New Jersey?
That's a good question. Can I reserve comment on that? Get back with me next year and see.
We had a budgetary question. Okay. The joke often heard around Trenton, politicians love to support campaign finance reform, they just don't want to fund it, which you've made a few allusions to. So if the state budget one day allocated lots more money to ELEC, what would you spend it on first?
Technology. I would definitely put the money into our electronic filing program, our website itself, and the technology that's available to our staff in order to do their jobs on a regular basis. Not to say that we can't do our jobs on a regular basis right now, but if we had unlimited funding, it would immediately go into technology.
One of the unique aspects of ELEC, and you referenced this in your opening remarks, is that the governing board has an even number of members, in this case 4. And that's always interesting because we see town councils, but you always have to have an odd number. Someone's got to break the tie. As I understand it, keeping the original 4 was part of the original legislation that created ELEC with the very intention of forcing compromise and consensus building. In your time at ELEC, has this been the case? Or does having an equal number of votes on the board lead to an inability to make decisions?
In my experience, the commission has had no difficulty whatsoever making a nonpartisan decision when it comes to, I'm not even able to think of right now a situation, final decision, regulation, advisory opinion, where they have split 2-2. The commissioners work together. They really believe in what we do. They take to heart, the mandate of the commission, and they move forward, I think, in the best interest of New Jersey, regardless of the party they maybe were assigned to when they took the position.
I want to take you up at a penultimate question here. The most egregious violation you've ever prosecuted. And if you don't want to use egregious, the funniest or most ridiculous, you had a war story, you referenced war stories that are like, is there one particular one that this was the craziest thing I've worked on?
So the impermissible use of campaign funds. You can imagine that a candidate sees a bank account full of dollars that they would enjoy spending on many, many things. And while I mentioned campaign expenses and ordinary necessary expenses of holding public office are 2 permissible uses, and they're very broad. There are also enumerated impermissible uses. You can't buy clothing. You can't have a fancy suit. You can't pay for your gym membership. I had a respondent who funded his gym membership and his parking tickets and a tuxedo and a trip to Puerto Rico for the Super Bowl every year that we successfully prosecuted and ended that behavior.
Okay. I mean, one can argue you need a tux if you're going to be a politician.
Agreed. But your contributors should not be.
There you go. Our final question that we ask everybody who comes here is a retrospective one for you, for everybody. You once sat in these seats as a college student. Now you speak from the podium as our honored guest. So the question we ask is, what do you know now that you wish you knew when you were their age?
So the first thing that I would say is, no matter what age you you will always think that you have no idea what you're doing, okay? Doesn't matter whether you've been doing something for 20 years or whether it's your first day. So approach things in that way. Realize that you're there to learn, and that the whole point is to learn and to get better. So dive in and learn as much as you can, because that's how you move forward.
On that note, let's thank Amanda Haines for a wonderful thing. I have been told that Ms. Haines is prohibited by ethics laws from taking this gorgeous, purple is the big color this year, this gorgeous RIPAC t-shirt that says on the back, just so we all remember it, Workforce Development for Democracy, which is what we do. I am ceremoniously giving it to you and then taking it back because you can't have this, okay? Because I understand. But we would have given it to you had we been allowed. You should know. Let's thank Amanda Haines again. Thank you.